Hello class, my name is Sarah Stracner, and this is HCA322, Healthcare Ethics and Medical Law. I have been chosen to be the plaintiff for Week 2, Discussion 2, the courtroom drama. I get very nervous when I have to speak in front of people, so I may trip and stumble over my words. I will do my best to keep my story straight. So for this discussion, I will be Jennifer, classmate. First, I will give the description provided word for word, then I will explain why I think AU Hospital is out of compliance. For this courtroom drama, we have been assigned Case 3, Public Health Corrects Impermissible Disclosure of PHI in Response to a Subpoena. The covered entity, General Hospital. The issue, Impermissible Use and Data Disclosure. Plaintiff, Jennifer, classmate. Defendant, AU Hospital. AU Hospital is a public hospital. In response to a subpoena not accompanied by a court order, impermissibly disclosed the protected health information, PHI, of one plaintiff, Jennifer, classmate. Contrary to the privacy rule, protections for informing sought-out administrative or judicial proceedings, the hospital failed to determine that reasonable efforts have been made to ensure that the individuals whose PHI was being sought received notice or to request and or failed to receive satisfactory assurance that the party seeking the information made reasonable efforts to secure qualified protective order. I, Jennifer, classmate, have brought AU Hospital to this court hearing to discuss how my personal information was released without my consent to a third party. First, I would like to state that I do realize my records were subpoenaed, but not with a court order. Therefore, AU Hospital should not have released my information without my consent. First, I would like to talk about HIPAA and what this means in my case. HIPAA stands for Health Insurance Portability and Accountability Act, a 1996 federal law that restricts access to individuals' private medical information. According to Smith, the Department of Health and Human Services Secretary Tommy Thompson announced on March 21, 2002, several proposed common-sense revisions to the HIPAA privacy rules. The privacy rules impact a variety of entities, including healthcare professionals, healthcare insurance providers, and employees with self-funded health plans. Secretary Thompson also stated, "The President believes strongly in the need for federal protections to ensure patient privacy." There's also several rules in HIPAA and why HIPAA was made. It gives patients more control over their healthcare information. It sets boundaries on the use of healthcare records. It establishes appropriate safeguards that healthcare providers and others must protect privacy of health information. It holds violators accountable with civil and criminal penalties that can be imposed if they violate the Patient Privacy Act. And lastly, it strikes a balance when public responsibility supports disclosure for some forms and data, for example, to protect public health. For my case, AU Hospital violated several steps in this rule. First, they took away my right to release my information to a third party. Second, they violated the safeguard that was set by their own company and failed to protect my privacy. Third, I am seeking the government sector called the Office of Civil Rights, or OCR, to seek all violators accountable with civil and criminal penalties. According to Smith, as health information technology continues to produce the paperless clinical enterprise, there is a need for a conscious health information policy. The Health Insurance Portability Act of 1996 required the adoption of these standards to support the federal law to protect the privacy of medical records and encourage the use of electronic methods for transmitting health information to establish standards and requirements. After reviewing the Patient Act that was established in 1996, UA Hospital has also violated the rights I will state below. Chapter 3, Maintaining the Dignity and Privacy of the Patient. 10A, the provider and all those working under his discretion and/or other workers in the medical facility shall maintain the dignity and privacy of all patients at all stages of treatment. B, the facility director shall issue directions for maintaining the dignity and privacy of patients in the facility. Chapter 5, Medical Record and Medical Information, the obligation to keep medical records. 17B, the provider or the medical facility, the director, shall bear for the maintenance and preservation of regular and updated medical records, in accordance with all permitted laws and regulations. Maintaining medical competency. 19A, a provider or any worker in the medical field shall not disclose any information regarding a patient which is brought to their knowledge in the course of their duties and their work. B, the clinic and the medical facility, the director of the facility shall make arrangements to ensure that the workers under the direction shall not disclose any matter brought to the knowledge in the course of their duties of work. Disclosing medical data to a third party. 20A, a medical facility may pass on any medical information to a third party of the following cases. A patient has consented to the disclosure of the medical information. 2, the clinic or medical facility are legally obligated to pass on the information. In my case, there was a subpoena with no court order. 5, the Ethics Committee has decided, after giving the patient the opportunity to voice their opinion, that disclosure of the medical information is vital for the protection of the health and others of the public and needed to be disclosed, overrides the interest of the patient. 6, the medical information is disclosed to the medical facility treating the patient or to the member of its staff and is the purpose for proceeding or filing information for notification required by law. Overall, AU Hospital violated my rights to protective information, and I am asking for the maximum consequence. I am not looking for financial compensation, but what I am looking for is that from this day, no other patient will be forced to deal with the same situation that I am dealing with. That concludes my portion of being the plaintiff. Again, I'm very sorry if I tripped over my words. I will provide a word-for-word text in the discussion section of our course.